All right, this is Rudy, January the 28th. As I state before every video, I do my best to read the words that are in front of me. If I make a mistake or two, I'm sorry for that. My advice is to get an actual copy of the trial transcript. Just like when someone's reading the Bible, you get the actual Bible and read along with them. I do the best that I can. I'm not a professional reader. My goal is to put these audio videos out for those who don't have access to the written trial transcripts. I'm on page 113. It goes up to 125. Let's continue. Mr. Hovind, please rise. All right. At this time, Mr. Hovind, I do formally adjudicate you guilty on counts 1 through 58 of the indictment, and that is consistent with the jury's finding of guilt as to each of those counts. Pursuant to the Sentencing Reform Act of 1984 and all amendments, it is judgment of this court that the defendant, Kent E. Hovind, is hereby committed to the custody of the Bureau of Prisons to be imprisoned for a term of 120 months. That is comprised of 60 months as to counts 1 through 56, all of which to run concurrent. 57 through 60 months. Consecutive as to count 57, and 36 months concurrent as to count 58, which results in a sentence of 120 months, which is within the guideline range. I want to note that this sentence is at the high end of the guideline range, and that is due to aggravating factors that I find present in this case, which include but are not limited to the number of obstructive acts that are involved in this case, which involve personal attacks against Mr. Scott Schneider and Mr. Powell, or Poe. I'm sorry if I mispronounced that. The revenue officer. Your personal attacks against those employees of the Internal Revenue Service were intended as personal attacks, and they are intended to smear the reputation and to ruin their careers. This type of behavior has continued. It is reflected in the tapes that we heard played here today. There is also the continued efforts to obstruct by hiding and concealing your assets in the face of this sentence, which would presumably include fines, and most assuredly would include restitution. I do recommend that the sentence be served and that Mr. Hovind be designated by the Bureau of Prisons to a facility for confinement as near his home here in Pensacola, Florida, as the Bureau of Prisons can accommodate. I don't make that decision. It is out of my hands. I do recommend, however, and the Bureau of Prisons does take my recommendation into account, but I do recommend that Mr. Hovind be housed, and I will specify Softly Field here in Pensacola, so that he may receive regular visitation from his family and friends. But again, that decision will rest with the Bureau of Prisons. I find that Mr. Hovind does have the financial ability to pay a fine in a modest amount. Mr. Hovind, you refuse to provide any financial information or financial statement to the court as required. But based on what I know, absent that financial affidavit, I find that you can pay a fine in the amount of $2,000 on a monthly installment payment schedule during your term of supervised release, which I will address in just a moment. While incarcerated, you will be required to participate in the Inmate Financial Responsibility Program, and this amount will be due and payable immediately. To the extent that you are unable to pay the amount in full, again, the remaining balance will be collected during the term of your supervised release. Pursuant to law, there is also a $100 special monetary assessment that must be ordered, and that is as to each of the 58 counts for a total of $5,800. This is due also and payable immediately. Pursuant to law, specifically 26 U.S.C. 7202, you will be required to pay the cost of prosecution in this case, and that is in the amount of $7,078.24. And that is under the counts of conviction in counts 1 through 12. Mr. Ritchie, all of this will be spelled out in a written judgment of conviction. Upon your release from incarceration, Mr. Hovind, you will be placed in a period of supervised release for a term of 3 years, 2 counts as to counts 1 through 57, and 1 year as to count 58, with the terms to run concurrently, one with the other. Supervision will be under the standard conditions adopted for use in this district, together with the following special conditions. Please listen carefully. You shall not own or possess, either directly or constructively, any firearm, any dangerous weapon, or any type of destructive device. And that includes any ammunition, and would also pertain to hunting weapons as well. You will be required to cooperate in the collection of DNA, which is required by statute. Also, pursuant to law, you will be required to make restitution, and the law is 18 U.S.C. 3583D in the amount of $604,874.87 to the Internal Revenue Service, Atlanta Service Center, Criminal Investigations Branch, P.O. Box 47-422, Stop 75B, Doraville, Georgia 30362. Mr. Hovind is to receive credit for any amount seized by the government. Restitution shall be paid in monthly installments of not less than $500 per month, and these payments shall commence within 3 months from your release of imprisonment. Any unpaid balance of the fine shall become a condition of your supervised release, and you will be required to pay not less than $61 per month towards that balance to commence within 3 months. Any unpaid balance of the cost of prosecution shall become a condition of your supervised release, and you will be required to pay not less than $100 per month to commence within 3 months of release as to that cost. You will also be required to provide the probation office with access to any requested financial information, both business as well as personal. You will be required to report the source and the amount of personal and or business income and financial assets to the supervising probation officer as directed. You shall not incur any new credit charges or open additional lines of credit without the approval of the probation office until you've satisfied your financial obligations under the sentence. You shall not transfer or dispose of any asset or interest you may have in any asset without the prior approval of the probation officer unless and until you have satisfied the financial obligations under the sentence. Although mandatory drug testing is required under the law during supervised release, I am going to suspend the requirement for drug testing in your case, Mr. Hovind, because I find that you pose a very low risk, if any, of any substance abuse. In making this sentencing decision, I do want the record to reflect that I did consult the guidelines. I calculated the applicable advisory range of 97 to 121 months based on base offense level of 22, 2 points for the pattern of unlawful activity, 4 points for the role of adjustment, 2 points for the obstruction of justice enhancement, no points for acceptance of responsibility. The total offense level is 30. Criminal history is category 1. Although the government has requested an upward departure from the guideline range, in other words, a higher sentence than has been imposed, and although I recognize that I have the authority to do that in this case, I find that an upward departure is not clearly appropriate, and therefore no departure, either upward or downward, will be imposed in this case. Finally, I consider every one of the factors in 18 U.S.C. 3553A in arriving at this sentence. And at this time, I do find that a sentence of 120 months in this case is sufficient, but not greater than necessary to comply with the purposes of sentencing set forth under the law. The total sentence is 120 months imprisonment, followed by 3 years of supervised release, a $2,000 fine, a $5,800 special monetary assessment, restitution in the amount of $604,874.87, and the cost of the prosecution in the amount of $7,078.24. Mr. Hovind, do you understand the sentence that's been imposed? Do you understand it? The defendant: I guess I would need to see it in writing first. The court: do you have any questions about what I've said as far as the length of the term of imprisonment, the fine amount? Do you understand what I've said? The defendant: I have a question. Since I have a vow of poverty, I don't own anything. The ministry owns everything. How am I supposed to pay? The court: that will be something that will be determined later. Whether or not you have the ability to pay, or whether or not the government can attach those assets, that's not a matter for me to determine today. That may come back before me, but it's not before me today. The defendant: I don't understand how I can do that, so I guess I need to get clarification on that. The court: well, there may be, in some instances, third parties have rights in forfeiture cases, and sometimes third parties file things within the court. And there is a hearing, and that may be where we get in this case. I don't know. None of that is before me right now. Mr. Ritchie can advise you further about that. The defendant: Your Honor? The court: yes! The defendant: as far as sentencing, obviously this will go to appeal. If there is any way that can be postponed as far as being implicated unto appeal, so I would have the sentence hanging over my head, but could go free on bond or on own recognizance. I just hope. The court: Mr. Ritchie can file something if he deems it appropriate. I have ruled on your motion for release and addressed in that ruling the issue of release on appeal. In this case, there is one overriding legal issue that I think that Mr. Ritchie and Mr. Behringer will pursue on appeal. The law, however, is that even if successful on that portion of the appeal, that would not affect the other remaining counts of conviction for which a sentence of imprisonment is called for. And so, therefore, that issue does not affect the issue of release. The defendant: all 3 counts, though, will be appealed, and it hasn't been determined yet. So I sure would like to go home until. The court: I understand, Mr. Hovind, that you would like to go home. I have to follow the law, and the law in this case is that you remain in custody. All right? Counsel, other than the objections that have been made and are placed and are preserved in the record, are there any objections to the court's ultimate findings of fact or conclusions of law as related to the sentence? Mr. Ritchie? Mr. Ritchie: as to the mathematics, no, Your Honor. But there were 2 just brief issues, and I'll try to be very brief. In regards to the restitution, that CR 32A2 says that a victim as an individual, as courts have repeatedly found, the IRS has no capacity to be sued or to sue, and they are not a real party in interest, which means they cannot be a victim in this case, and under 18 U.S.C. 3583D, that does not include Title 26. The court: Ms. Heldemeyer, do you wish to respond before I proceed? Ms. Heldemeyer: if Mr. Davies could respond, Your Honor. The court: Mr. Davies? Your Honor, the case law is, in a case such as this, you can make restitution for the Title 26 offense is a condition of supervised release. So it's appropriate under Title 18, which you cited in your sentence. Mr. Ritchie: Your Honor, then I'm sorry. In reference to that, you had stated that he must pay $500 a month beginning now. that, as he just stated, that would only take place in restitution, which begins in supervised release, which would be inappropriate to order him to begin payment on that now. The court: I would agree with that, Mr. Davies. I think Mr. Ritchie raises a valid point. So the judgment will be amended to reflect that the restitution payment will begin 3 months following the release from incarceration. Mr. Ritchie, one other thing, Your Honor, was on the bill of cost. There's no receipts included in this to substantiate it. And for example, just on number 2, they want $3 or $5 per page on grand jury transcripts. And I believe the figure on that is much less per page. So I would ask that the government produce receipts in order to substantiate. The court: Mr. Davies. Mr. Davies, Your Honor, we cite in the bill of cost the Patty case and also the Dean case. The Patty case, both of which were in district court, but Patty went up to the 11th Circuit and got affirmed, and it specifically affirmed that the $5 per page for the transcript, which is what we are charged for grand jury transcripts without a court reporter, and 50 cents per page for copies, has been affirmed by the 11th Circuit. So you have the discretion according to the Patty, 11th Circuit Patty case, and I think your imposition was correct. The court: That's the law, Mr. Ritchie, and that amount won't change. Miss Heldemeyer, any objections from the government? Miss Heldemeyer: No objections, Your Honor. The court: Mr. Hovind, you do have the right to appeal from this sentence. If you choose to pursue an appeal, you must file your notice of appeal within 10 days of the date of judgment. And this will be in writing, and it will be entered early next week. So you will have 10 days from that date of judgment in which to file your notice of appeal. If you cannot afford the costing of an appeal, you may file for leave to appeal in form of papyrus or no cost to you. And upon request, our clerk of court would file a notice of appeal immediately on your behalf. I know Mr. Ritchie can advise you further about your appeal rights, but please do remember, it's 10 days from the date of judgment. Mr. Ritchie: Your Honor, if I may address one thing just quickly on that, a notice of appeal was filed and it was paid, but the clerk's office for some reason interpreted it as interlocutory appeal, even though in the notice of appeal it said judgment and sentence. And my understanding is even if the notice of appeal is filed prior to the judgment and sentence, it still applies. One judgment and one sentence is issued. Do I need to file an amended notice of appeal? The court: Well, you threw us a curve on that one, Mr. Ritchie, and we weren't sure. And I believe we consulted with the 11th Circuit, and we told it would be treated as an interlocutory appeal, the appeal that you filed. So I am not here to give advice, but it might be, Mr. Ritchie. May I request that the court order that it be allowed to be in the final notice of appeal rather than the interlocutory? The court: I don't think I can do that. It's however the 11th Circuit treats it. Again, I can't give you advice, Mr. Ritchie. I'm moving the court to do that. The court: To just file an amended notice of appeal? Mr. Ritchie: To allow me to file an amended notice of appeal and for that to apply, that the filing fee be already paid. The court: Mr. Ritchie, I don't know that I can do that. I mean, that's not something I can give you an answer on right now. The judgment of conviction has been entered, so your time period is not running, so you don't need to worry about that. So that's something you'll need to research and see what you can do, or the court has authority to do. And you need to let me know that. And if I can, I'll be more than happy to treat it as such. I just don't know that I have the authority to do that, because the judgment has not actually been entered. Mr. Ritchie: And then one last final matter. I'd request that the court grant that Mr. Hovind be given credit for the time served from the time of his incarceration after the verdict. The court: He will automatically be given for that time. Mr. Ritchie: Thank you, Your Honor. The court: All right, we've rescheduled Mr. Hovind's sentencing. I believe the date I gave you was March the 1st. Mr. Behringer, that's correct, Your Honor. The court: All right, And we will see you and Mrs. Hovind back here at that time, Mr. Behringer. Miss Hovind, you are still in pre-trial. Well, you're still under supervision on pre-sentence release. There are terms and conditions, you know, I'm sure that you must abide by. Continue to abide by during this period of your release. Make one modification to the bond, and that is that you appear for sentencing here in this court on March the 1st at 9 a.m. Defendant Joe Hovind. Yes, ma'am. The court. All right. Court in recess. Okay. That's the end of the trial transcripts, the sentencing trial transcripts that occurred to Kent Hovind and Joe Hovind on January the 19th of 2007. Basically, they were surrounded by a bunch of devils that had a satanic worldview, and they did not recognize what's going on. And I pray Psalms 109 on Judge Margaret Casey Rogers. I pray Psalms 109 on Prosecutor Michelle Heldemeyer. I pray Psalms 109 on IRS Agent Scott Schneider.